G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and welcome to the Australian Family and Fertility Law podcast. Today, my focus is on South Australia. And I should say, if you're watching this on YouTube, don't forget to subscribe. We love our subscribers. Thank you. But as I said, today, the focus is on South Australia. The Surrogacy Act 2019 says there are two forms of surrogacy agreements in South Australia. Those that are lawful surrogacy agreements and those that are not. And you go, okay, other states talk about surrogacy arrangements, but they talk about surrogacy agreements. What is a lawful surrogacy agreement? Well, it's either a South Australian agreement, and of course it's got to be altruistic, and then there are a whole series of things. But the legislation also talks about interstate surrogacy agreements under prescribed laws. And you may say, okay, well, what are we going to do? There are clearly going to be prescribed laws, and you start looking through regulations and then discover there are no prescribed laws. And the Surrogacy Act is quite clear that if you have a surrogacy arrangement or surrogacy agreement in South Australia that doesn't fit the bill, in other words, it's not under prescribed law or it's not a South Australian lawful surrogacy agreement, it's unlawful. Doesn't mean it's an offence, so you can have an altruistic one that's not an offence, but on the face of it, it's unlawful. So when you look for those prescribed laws, there are none. And what does that mean? Well, if you've got a South Australian surrogate for interstate intended parents, they don't do that under a South Australian surrogacy agreement. They do it under an interstate surrogacy arrangement, and on the face of it, that's unlawful under South Australian law. And I thought, okay, this is an oversight. So I wrote to the South Australian Attorney General and I said, can you fix this obvious oversight? You know, obviously someone's forgotten to switch this on. It's been forgotten, it's not an important thing necessarily. And the response back was, no, this wasn't an oversight, this was a deliberate decision. So there you have it. If you have a surrogate in South Australia for an interstate surrogacy arrangement, on the face of it, it's unlawful. It's not a criminal offence, but on the face of it, it's an unlawful surrogacy agreement in South Australia. So there has to be careful legal advice given to the intended parents and the surrogate, and the surrogate got a partner, about the implications of that. Quite an odd way of looking at the world, but that's the decision the South Australian government has made. Thank you for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers. This is the Australian Family and Fertility Law podcast. If you're watching this on YouTube, don't forget to subscribe. We love our subscribers. Thank you.